Welcome to another episode of Tea Time with Sunita. We are continuing our conversation with Scott Mozingo from Highland Title, who is an attorney with them, and we wanted to ask some more questions. We dealt with basic questions about title insurance, and because settlement company is a very large component of the closing process. And I wanted to kind of ask him a few more questions regarding the different aspects that we are seeing more and more when we see the closings or when we are going to listed properties. One of them is a trust. I see that all the time. Scott, can you explain a little bit about what is a trust?
Yeah, sure. A trust is really an estate planning tool. It's a way to get property from, mom and dad to the kids. And one of the nice things about a trust is it avoids probate. You don't have to, it's not like a will where you have to take it to the courthouse and probate it. So it is an estate planning tool. And like you said, we are seeing more and more trusts where people are selling, they're buying in the name of the trust, and using that trust to sell down the road, because maybe they didn't pass away before they just needed to sell the house and move to Florida. So now they're selling in that name of the trust. So we are seeing more and more of that.
Okay. Are there different kinds of trusts?
Yeah, so typically what we see is what's called a revocable trust. This is, mom and dad, Mr. and Mrs. Smith, they bought a property, they are trustees of the trust, they're the initial trustees, and then when they go to sell the house, they're still the initial trustees of the trust. Okay. There is another type, it's an irrevocable trust, or an irrevocable trust. This is basically a couple different ways to get there, but one of the more common ways is mom and dad both passed away. And now one of the children is the trustee, the successor trustee of the trust. Okay. And so they're just managing the trust. They don't have the ability to change anything like mom and dad had with the trust, but they're kind of the caretaker that are now executing the terms of the trust.
Okay. Is there a benefit of having a trust, creating a trust?
Yeah, the benefit is, and I do advise that everybody talk to their estate attorney. It is important. There are different ways to handle it, whether it's a will or a trust. Even a transfer on death deed, there are different ways to get to the same result. And a lot of it's going to plan on kind of tax planning and things like this. But for our purposes, for the title company purposes, I love a trust. It's much easier for us to deal with than a will that's been probated at the courthouse and figuring out who the executor is, or if there was an executor, or if, the worst case scenario is there is no will and there is no trust. And it's just, that somebody's getting appointed as an administrator of the state, or all of the heirs would have to sign. So for me, the trust is definitely helpful when it comes to selling the property, whether it's mom and dad selling the property, or if mom and dad have passed away, the children selling the property.
Now, from a real estate point of view, I am seeing, when you go into the, what you call public history of the properties, you see a property being held in a trust. Now, when I'm going to list a property, what are the kind of documents that I should be asking for, and what are the documents that the seller should be thinking about collecting beforehand to hand over to me so that I can pass it on to the future buyer?
Yeah, that's an excellent question. In fact, I got an email about that on my way here this morning with the closing that we have coming up. And so when you take the listing, if they're saying it's in a trust, or you see in the tax records that it's in a trust, definitely recommend that they need to have a copy of the trust on hand. There are some possibilities that maybe we don't need to see the trust, because one of the purposes of a trust can be for privacy purposes, because you don't have to record it at the courthouse. So sometimes people are a little reluctant to give up the trust, but you definitely want to have that conversation with them when you take the listing and say, hey, have the trust agreement ready to go. The title company might need to see it. And if they're a little hesitant, I can even I don't need the entire trust. I don't need to know what happens with all of their personal property. So I might only need 4 or 5 pages with the name of the trust and who can sign and can they sell real estate and the signature pages. And as long as I have that, I'm typically okay with going ahead and clearing title and allowing them to sign as the trustees.
You just mentioned about the signing. Now, that is something. Who do you think, because people do have questions, who is going to sign for this? Now, anytime a property is held in a trust, who signs for it as a trustee at the time of closing?
So if it's your typical Mr. and Mrs. Smith, mom and dad own the property, they're still alive, they were the initial trustees in the trust, then it's going to be the two of them signing. Now, the trust might allow for only one of them to be needed for the purposes of signing. as somebody that clears title and kind of makes sure the title is clear for the next person, I always prefer to have both of them sign. But there are times where maybe the husband is overseas, or something where they can't get there to sign. Maybe there's some kind of medical condition, whether it's dementia, Alzheimer's, something like that, and they can't sign. And so, a lot of times the trust will allow just one of them to sign. And so we can do that. The one that gets a little more complicated is if mom and dad have both passed away. Then who can sign? It's going to be the successor trustee. And in that instance, I really am going to need to see the trust to see who the successor trustee and that they have the powers there. The other thing that other document, going back to that question, that we would need at that point is the death certificate for mom or dad, whoever's passed away. If you do have a death in the family as part of that ownership, whether it's in a trust or not, we're going to need the death certificate.
Okay. Like in a normal sale, but if one party cannot be there, we can always get a power of attorney. Do you think in a trust a power of attorney would work?
Typically, it does not. So in Virginia, there is some allowance for using a power of attorney for the trust, but it has to be very specific as to the power of attorney and the trust allowing it. So usually that's not the case. It brings back to memory, I had a case a number of years back, and the morning of settlement, the wife had fallen down the stairs, broke her leg. They had taken her to the emergency room, and so we got a phone call saying, what do we do? And so I said, well, let me look at the trust. We might just need the husband's signature. And I read through the trust, and it said, Mr. and Mrs. Smith, either of whom may act. And this is kind of the magic words, and I'm thinking, okay, good, the husband can act. And unfortunately, the next phrase said, except for the sale of real estate. And so I did need both of their signatures. So we couldn't use a power of attorney. Unfortunately, we need both their signatures. Luckily, mom was fine. She just had broken her leg. And so we sent a notary out to the hospital, and she signed that morning in the hospital, and the husband brought the documents with him, and then he signed with us, and we were able to take it through. So there is a possibility, and that has come in handy in numerous instances where one of them can't sign, where we can just have that other trustee sign. But there are some times where they both have to sign. Yeah.
Thank you, Scott. This has been a lot of information, and that good information for all of us over here. In the future, if you have any questions, please reach out to me or to Scott Mozingo, and I can get your questions answered. And for now, that's the tea.